We turn now to another high-profile murder trial. In Kenosha, Wisconsin, prosecutors continue to make their case against 18-year-old Kyle Rittenhouse, who's accused of killing 2 men and wounding a third during a Black Lives Matter protest last year. Rittenhouse, who traveled across state lines from Illinois to Kenosha carrying an AR-15 style rifle, claims he shot the men in self-defense. The prosecution and the defense gave their opening statements on Tuesday. Let's take a listen.
He acted in self-defense, ladies and gentlemen.
There is a privilege under our laws to use deadly force, but it's a very limited privilege. Hundreds of people were out on the street experiencing chaos and violence, and the only person who killed anyone was the defendant, Kyle Rittenhouse.
So far, 4 witnesses have already taken the stand, including a friend of Rittenhouse's, the lead detective on the case as well. The prosecution also showed the jury one of the central pieces of evidence today, a video showing Joseph Rosenbaum, one of the men killed, chasing Rittenhouse and throwing a plastic bag at him. Back with me are my legal experts, criminal defense attorney Brian Watkins and former prosecutor Rosalyn Charles, who is now joining us. Thank you so much for coming on the show, Rosalyn.
Yeah, thank you.
All right, before we get to those opening statements, it's hard not to notice how quickly this trial is moving compared to the trial in Georgia, especially since jury selection in Rittenhouse's trial started well after. And it's understandable why many will be comparing these 2 high-profile trials involving white defendants who carried guns, who went vigilante, and point out the disparities, starting with the timeline. But every case is different, with a bunch of factors to consider when trying to make sense of it all. How would you guys explain to folks who are already critical of the jury selection process in Georgia why it's already day 3 in the Kyle Rittenhouse trial, while we're still debating the racial makeup of the jury involving the McMichaels and William Bryan? Brian, you first.
You know, the funny thing about the Rittenhouse trial is there's a white defendant and the victims are also white. And so I think that their defense attorneys aren't really keen on the race issue right now. I think that they were looking for different types of individuals who are pro self-defense, probably pro gun rights. And so those were the issues and what they were focusing on to try to get jurors that fit who they thought would relate to Mr. Rittenhouse. So I think race played a back seat to that situation.
All right, well, now to those opening statements. Rosalyn, what did you think of the prosecutions?
I found the prosecution's opening statement very straight and forward and to the point. But I would also describe it as a little lackluster. I don't see where the prosecution really allowed the jurors to get an opportunity to see who these victims were, at least to have some kind of connection with the particular victims. You focus primarily on the acts of the defendant, which is key here, of course. But during your opening statement, you do try to get the jury to experience what the victims may have experienced from that point of view. I was a little concerned about that, but that was my analysis of the state's opening.
Brian, the defense is arguing Rittenhouse shot the protesters in self-defense, and we know that the judge has ruled on a few issues that will be favorable for their case. Is self-defense in this case more likely to work than it will for the McMichaels?
You know, I think it's going to be a problem in both cases, because in both cases we have people doing what you've referred to, and I agree with, vigilante justice. And the fact that somebody resisted my vigilante justice, now I'm in defense of them defending themselves. And that's the twist here. You know, he says that he was out there with a gun. He says that he shot, I think, victim number 2 because he had a gun. Well, you had a gun too. So technically he could have shot you. So you can't defend yourself against somebody who's defending themselves against you. And I think that the defense is going to have a problem with that, because the key to self-defense is you can only use deadly force when you're under threat of imminent, and that's the key word here, imminent, great bodily injury and or death. So he can't shoot somebody because the guy could have done something to me, you know, and you can't use a gun in a fist fight. So the shooting of the unarmed individual is going to be tough, and the shooting of the guy who had a gun is going to be tough, because the guy with the gun didn't do anything threatening. So he wasn't in imminent danger. of suffering great bodily injury or death. So he jumped the gun on his use of self-defense, and I think the case is pretty straightforward. And the same with the Aubrey case. You know, Mr. Aubrey didn't do anything. He didn't have a gun. And the fact that he reached for your gun because you put a gun on him is his self-defense against you. And you don't have a right to use self-defense against him using self-defense against you. And I think that the defense is going to have a real problem getting her over that hurdle.
Rosalyn, let me get your take on the judge's recent rulings not allowing the prosecution to call these individuals who died and one that was wounded victims. It will allow the defense, however, to refer to them as rioters and looters if they can prove that they were those type of people. What are your thoughts, and how harmful is that for the prosecution?
I don't necessarily know that it's harmful to the prosecution. However, I was concerned when I heard the judge make that ruling, because he's decided to, based on whatever argument was presented before him, to allow these individuals to be characterized in a nefarious sense, if you will, or in a very pejorative sense. And I quite frankly would have preferred that he left such a, not so much the ruling, but just allowed them to be either victims or at least people, but not describe them in such a pejorative sense, because that's a conclusion, I think, that if the jury was even going to come to that conclusion, that is a conclusion or an assessment that the jury should make. So I do find it concerning.
All right, let's talk about the witnesses that were called to the stand. The prosecution's first witness, I was a little confused, was Rittenhouse's friend Dominic Black. He's the person who actually bought the rifle for Rittenhouse and is facing charges on his own. Were you surprised that he was their first witness, Brian?
I was. You know, I didn't think they would start out like that. I thought that they should have started out a little different and go straight to the heart of the crime. But that was kind of a lackluster introduction. You know, I didn't really get much out of his testimony, and I don't really understand what the point is. How does that say it is or it is not self-defense? And so, I mean, we all understand that he was armed with a gun. The fact that this guy bought it for him, I didn't really connect it. Now, maybe it will come together for us at the end and we put all the pieces together in closing argument. But like I said, it left me at the beginning with a little question mark, but maybe that's a good thing because I scooted up on my seat and listened further to see, hey, how does this fit in and where are they going with this? So I was, you know, it was a little strange for me, but, you know, it didn't turn me off completely.
Well, the defense cross-examined Black, who is, again, facing 2 counts of intentionally giving a dangerous weapon to a minor, resulting in a death. Here's part of how that questioning went. Defense attorney Mark Richards said, so your trial on these charges, which Mr. Binger, who's the prosecutor, is prosecuting you for, was before today, to which then Black responded, yes. The attorney Richards then said, and you and your lawyer and Mr. Binger walked into this courtroom and asked that the matter be set over until January 2022. After you testified here today, correct? Black responds, yes. Rosalyn, could this line of questioning or this cross-examination of this witness be an attempt to imply that the prosecution may have worked out something with Black in exchange for his testimony?
Oh, that's absolutely why that line of questioning was put before this particular witness. And the defense is going to try to make hay of that with respect to and draw some kind of conclusion, or hope that the jury will draw a conclusion that his testimony has been bought and paid for. But again, the testimony that I saw of this particular victim, and he bought a gun, they engaged in target practice, and he bought a gun and he was his friend. So, but yes, I can certainly see where they could make that inference, but I don't know exactly what they're going to be able to say with respect to the testimony. It was indeed elicited from him. I believe the jury will take in and not draw any particular inference from.
And I honestly didn't think that line of questioning was necessary, given the fact that his testimony wasn't really damning for the defense anyway. Brian Watkins, Rosalyn Charles, thank you so very much for your time tonight. Appreciate you.